Hello, everyone. In this episode of Kaffeeklatsch, we are here to discuss the leniency regulations of India. And the occasion is a recent research paper published by Professor T.S. Somasekar of NLS or the NLS-IU Bangalore. In this paper, which he has co-authored with Professor Praveen Tripathi, they have taken a systematic look at the leniency regime, and they have statistically looked at its performance. And therefore, we have some new insights on the functioning of the leniency regime in India. To discuss the subject with us, we have today the author, Professor Somasekar, a well-known competition economist and a professor at NLS and well-known in other areas as well. Welcome, Professor Somasekar.
Thank you very much. Pleasure to be here.
I have with me Mr. Manas Chaudhuri, an extremely well-known competition lawyer. And in fact, he has been part of the Indian judiciary and subsequently Defense Ministry, Monopolistic and Restrictive Trade Practices Commission, and then CCI. And last almost 2 decades, he has been practicing as an independent counsel as part of various firms. And he has watched the evolution of Indian competition space at a very close quarters. Welcome, Mr. Chaudhuri.
Thank you. Thank you very much, Navneet.
So let's begin the conversation and first understand the need of leniency regulation per se. Why do we really need it? What causes this in India and elsewhere? And let me begin with Mr. Chaudhuri, that the need of leniency regulation and how it has evolved in India so far in the last about 15 years or maybe more.
So thank you, Navneet, for this question, because that's one of the most cardinal questions which every industry who we represent before the CCI and the Director General and subsequently before the Appellate Authority, because end of the day, the business houses have got a defense that I'm doing business. Why should someone come and become an additional gatekeeper to my doing business? But on the other hand, the competition law, which has been passed by due process of Parliament, and I can tell you here as a lawyer that many people say that under Article 19(1)(g), I have got a right to freedom of trade and commerce. Why should an authority come and become a gatekeeper to my doing business freely, which is a fundamental right? But then more often than not, people don't realize that in the same constitution, that is under Article 19(6), the state has one very interesting things to abide by, which is a reasonable restriction as the government may like to impose. So what I could say here is that despite that it is a fundamental right of doing business under Article 19(1)(g) of the Constitution, the state and the Parliament has also a right to put a reasonable restriction to that freedom of trade and commerce. And Competition Act is a 19(6) regulation in my view, because it is putting reasonable restriction. It does not really bother about your business agreement, your commercial relationship with an independent enterprise, whether in the same business level or in the vertical chain. The law does not really frown upon all of that. The law is only frowning upon a delta of your commercial relationship, which is your conduct. So unlike any other commercial law, no authority is bothered about the conduct of the parties to the contractual obligation. Competition Commission is only bothered about your conduct. They are not bothered about your clauses of the agreement. They would see, and in the process to understand your conduct, they would of course read between the lines some of the clauses of the agreement, if there are availability of the clauses. But as Navneet, you raised a question, why leniency? The problem with regard to leniency is that these agreements, which are generally entered into between competitors, that is, people are in the same business level, that is a competitor of company A and its competitor B. So when they enter into agreement, it is more often than not in a written form, unless it is a joint venture or a franchisee agreement or a merger or amalgamation. Most of the time, the cartel kind of an agreement is not written, it is always shredded in secrecy. And that is the reason the Parliament has broadened the definition of agreement in Competition Act. It very typically says that any agreement between independent enterprises which are not even enforceable in law, but an arrangement, agreement, or any tacit collusion are considered to be agreements. Now, this definition of agreement clearly gives us the indication that the authority created under Competition Act, that is CCI, and its investigative arm, that is the Director General, both they try to find out as to how the parties to this agreement are operating in a market with their conduct, which is entered into in secrecy. And when they are entered into in secrecy, obviously, the law says which are the prohibitory decree of horizontal agreement. You cannot have a price fixed between two of you, or you cannot allocate the market between two of you, that you take South India, I will take North India. Or you also cannot limit production artificially, thereby artificially raising the prices together. And of course, the fourth one is the bid rigging. Whenever you are participating in a public bid, and you should not be colluding the bid, you should not be rotating the bid, so that you are actually distorting the market, and ultimately the taxpayers are at the loss. So the question to you, Navneet, and the answer to that question is why there is a leniency. Leniency is a regime where the law itself has created a carve-out that the parties to a cartel, one of them turns an approver. Typically, like criminal law, one turns an approver of the government in a criminal offense and gives the evidence against all the co-accused. It is almost identical to that. One of the cartel members comes before the CCI under a prescribed lesser penalty regulations and then discloses by clinching evidence between them, which may be a WhatsApp message, could be SMS, could be even anything, a call detailed record, whichever can constitute that tacit understanding or direct understanding or a concerted action in terms of the agreement, which is very broad, then the CCI will have jurisdiction to investigate the cartel very, very in a methodical manner. I stop here unless any other questions.
I mean, you would recall that it was only in 2009 that the enforcement of Section 3 started. And post that, can you briefly capture how the lesser penalty regulations were introduced and how they have evolved very quickly, so that then we can get into the substantive paper?
Yeah. So I think, the question is very fundamental, because if you see, when in May of 2009, when the enforcement relating to Section 3 and 4 were notified, simultaneously two other notifications happened. One is the constitution of the appellate tribunal, because unless there is an appellate tribunal in place, whenever the CCI passes an order, there is a period of limitation within which you can go for an appeal against the order. If there is no appellate tribunal, obviously it becomes infructuous. So three notifications happened. One, setting up of the CCI's Section 3 and 4 regime, setting up of the competition appellate tribunal, then it used to be called the compact. And third is the lesser penalty regulations of 2009. Now, lesser penalty regulations must come simultaneously with the enforcement notification of Section 3, subclause 3, because it only talks about lesser penalty only pertaining to cartel. It does not talk about vertical agreements or abuse of dominance. So it simultaneously came with that intent that since there is always very difficult for the investigator as well as for the CCI to get smoking gun evidence against competitors indulging into cartel, because they would try to keep it secret, you can always infer that the prices have gone simultaneously together. Immediately they will come and say it's a price parallelism, may not be cartel. So all of these arguments can only be substantially met if you have got a lesser penalty regulation, which means one of the parties under an affidavit as per the prescribed regulation discloses the cartel in such a manner that the others who are member of the cartels are also exposed. And that becomes a smoking gun evidence for which the DG may further consolidate that evidence by calling the parties to its office and take oral testimony on oath by showing those evidence which has been disclosed by the applicant. Now, once that investigation process starts, perhaps the other members of the cartel might think that, well, why not I also go and ask for certain kinds of mitigation so that my penalty also gets reduced. So the lesser penalty regulations typically drawing persuasive value from the West. What we have done is the first applicant, if he is able to make the CCI form the prima facie view, normally gets 100% immunity from penalty. The person who comes second normally gets up to 50% of the penal consequences immune, and the third gets up to 30% of the penalty of the total computed penalty. Now, this staggering of 100, 50, 30 is nothing but an incentive to rectify the market failure arising out of cartel, since cartel, you know, is the most pernicious form of anti-competitive practice, is actually harms the market so directly that the taxpayers are the real sufferers in this case. So naturally, it is a incumbent duty of not only the state, but also of the authority to remedy this to the extent it is nullified to zero. And leniency is almost, I can give you another example. I'm sorry to draw that parallel. Say, for example, 5 people have committed the crime of murder. And that is section 34 of the IPC, which says the common intention. Everybody has the intention common to kill X, and X died. Now, during the process of this investigation by the police, one of them turns government approver. And the moment the person turns government approver, and he continues to remain along with the investigator until the final order is passed, that person normally gets exonerated, acquitted with honor. That same logic is applying in the case of leniency. One of the cartel members discloses the cartel, CCI finds, the DG finds that the evidence adduced by the parties are so sufficiently enabling them to conclude the investigation against all others. They will give 100% immunity to the first person who turned the approver, and remaining will be given lesser penalty, like in the criminal cases also. So this is the basic fundamental intention, and across globe, this is what the intention is, to remedy the cartel from the market and keep it a deterrence, so that even if there is a, you can say, a balancing act of giving immunity plus also putting the others into some kind of a problem, that with 50%, any company can really have a huge liability of penalty. For example, I can give you one example, one of the leniency cases as we go forward. I can tell you one of the party was handed out with the second immunity benefits. It almost exited the market because the penalty is so high that it could not sustain the penalty.
Let's come to the effects of that in a while.
Correct.
Having set the foundational background of how the leniency regulations came into picture and how they have evolved, let me turn to Professor Somasekar, who has conducted this very comprehensive study on evaluating the leniency regime. Firstly, how did you formulate the research problems? And tell us a bit about the methodology, so that our audience can be sure that the methodological robustness is there. Therefore, the findings of the paper are to be relied upon and tested further. Let's first go to the foundational questions. How did you formulate, and what are the methodological or conceptual foundations you relied on? Professor Somasekar. Unmute yourself, please.
So that was a very elegant and nice backdrop given by Manasji. So makes my task that much more easier. So why exactly did we undertake the study? Now, we know, as already pointed out, how critical leniency is for the purpose of detection of cartels. They're extremely difficult to detect. And the leniency program helps the CCI to that extent by reducing the transaction costs and the kind of administrative expenses that they need in order to detect cartels. And breaking cartels is very important because they have a significant impact on market efficiency as well as the GDP of countries. So leniency program must succeed in order for us to deter cartels. But has it succeeded is a question. So we set out to see if there are actually good empirical studies which examine this leniency program in its entirety, because It has been nearly 10 years. When we started off the study, it was 10 years of the CCI's journey. And we found very, very few papers which actually dealt with the leniency program. And among those few, we found that none actually dealt with it in an empirical manner. Well, these papers did say that, some said leniency program has succeeded, some said leniency program has not succeeded, and some others also forward to say that leniency program has not succeeded because of uncertainties. But none of them substantiated their statements with empirical data. And none of them also emphasized on why and where exactly the leniency program is failing. So this was a huge gap in literature, which we thought would be a good idea for us to address. So that was a motivation behind taking up this particular study. Now, the methodology that we adopted was both theoretical as well as empirical. Theoretically, we took a look at the provisions and to see if there were any kinds of biases that existed. And we did find something there. And secondly, it was empirical, very empirical in nature. We took the entire set of cartel cases for which we had decisions by 2021. And we took all details with respect to the orders in terms of mitigating and aggravating factors, how penalty was decided, what provision was utilized. So we took a very comprehensive look, both from a macro perspective in terms of number of cases, as well as from a more disaggregated perspective in the sense that what kind of factors influenced CCI's decision making in terms of determining what amount of penalty should be imposed. And then after gathering this data, that's why we say it was comprehensive data, we filtered out certain types of data which wouldn't be relevant. In the case, certain cases, CCI did not penalize anyone. So those would be outliers which would distort our findings. So we removed them. They did not penalize in the sense that they just levied nominal fees. So we excluded them, very nominal penalties. And the second thing that we did was we didn't just stop with descriptive statistics, because descriptive statistics may not allow for controlling of mitigating and aggravating factors which CCI may use in order to determine the penalty, which is what we found as a limitation in the other papers. They said the penalties are very indeterminate and not transparent, but they didn't take into account mitigating and aggravating factors which CCI uses in order to determine penalties. So we took those factors as well and went ahead with a comprehensive econometric analysis of that to establish what exactly is out there. So this was the methodological approach that we had.
That's really nice. Can you help us understand in a crisp manner the statistical overview of the outcomes you found there, the overall performance of the leniency regime? Can you articulate that statistically?
Okay. So firstly, I'll give theoretically, and then I'll give the statistical too, because it helps to understand why the results are so stark. Like Mr. Manas has already pointed out, the relevance of a smoking gun. Now, there are two types of probabilities that are involved here. Firstly, the probability of detecting a cartel, which is, no one can actually compute that, although studies have attempted to compute that. And that is the probability of detection. And the second one is the probability of a cartel having been detected, then being established as an actual cartel and being penalized. So there are two probabilities there. The first probability is the one which is extremely low, detecting a cartel. Right? Now, we say that once there is a cartel detected through prima facie establishment by the CCI that there is a cartel here, now you have a smoking gun. Now, what happens immediately, theoretically, is that now you know that it's almost certain, going by the history of data that CCI, that in terms of CCI's decision making, with a 90% probability, firms that have been found prima facie guilty of cartelizing or bid rigging, they have been found and have been penalized, at least by CCI's orders. They were, of course, being challenged. So once you have a prima facie case, there's a 0.9 probability of you being penalized. That's very high. So that should automatically tip the scales towards a firm going forward and seeking leniency, because now suddenly the cost-benefit ratio has changed. Earlier, with a very low probability of being detected, you would say, well, the benefit is certain. I mean, we are hardly going to be penalized. Now there's a smoking gun. And that should have actually caused them, a prima facie, finding should have caused them to race to the CCI saying, let's get this out and, let's try and avoid a penalty. So that is what we were trying to test. And the data is very stark. 32 distinct cases. There are 44 cases, but 32 distinct cartel and bid rigging cases, of which 29 had a penalty. You only had 7 leniency applications, which is just 20% approximately. Now that's extraordinary. Now, why didn't, because it clearly tilts the scale in terms of cost being higher than benefit. Why didn't they go to the CCI, right? So the first statistic that we point out is that, look here, data says it. It's just 20%. And there should have been a race, but there's no race. So that's the first statistical point that I want to make.
But you found out that this tipping or this rush was not created,
Yes.
right?
Yes.
And what explains that corporate behavior? So take us through some of those findings which you have found as to why companies participated or chose not to participate. Throw us more light on that, please.
Yeah, thank you. Now, of these 7 leniency cases, 6 of them, led to the detection of cartels that had already, stopped functioning. And only 1 led to the detection of a cartel that was still, ongoing, which in itself is again problematic, because you want to encourage cartel members to come forward and, confess on an existing cartel to prevent the damage from furthering. But this is also something that has taken place, caused damage, and so on. Now, why exactly did these firms come forward and admit? Was it because that they were worried, oh, that's the CCI and we're going to get penalized? Not really. Why really they came forward was because of some other factors. It was not because of CCI's penalty, which is 3 times your profit for each year of the cartel period, or 10% of the turnover for each year of the cartel period. No, I don't think that we didn't find that kind of a reason for why they came forward for leniency applications. Rather, it's very interestingly, it seems to be developments outside. In certain cases, it was a failed merger. And because these 2 parties failed to merge, one goes forward with a leniency application. And in another case, there was this information that was already provided to another ministry where they were discussing trade-related issues with respect to dry cells imports. And one Indian firm actually complained saying that, hey, these other firms are cartelizing. And unfortunately, that particular department doesn't reach out to the CCI and say, look, there's this complaint, investigate that. But that is what has prompted another company, a Japanese company, to go ahead and have a leniency application. So quite a few cases, almost 80% of the cases in which you had a leniency application, it was not really motivated by CCI's own, or the Competition Act's provisions related to the penalty, or to the Act's provisions related to leniency that motivated these firms to come forward with a leniency application. It was an external shock. So that's the reason why when we come forward with our solutions later, we say there must be more external shocks with simultaneous internal developments. So it was not at all, we don't overwhelmingly, the evidence is that it's not to do with the Competition Act at all. It's not to do with the deterrence level of the penalty or the leniency framework. It's external shocks which have induced these leniency applications.
That's very interesting observation, Professor Somasekar. Let me bring in Ms. Chaudhuri here because he has observed these developments as a lawyer. And I would like to have his reflections firstly, and then also delve a little more on this nexus between cartel and merger conduct. How the two establish a bridge, how companies look at the cartel activity and the merger activity, and how they engage in the two. I would like to have some reflections from you, Mr. Chaudhary.
Okay, thank you. One thing I would like to draw a persuasive value from Professor Somasekar's opening remarks. The leniency in India, as on today, if you see that the total number of leniency applications filed, let's not go into the detail of how they have been concluded. If you see the filings right from 2013 August, which was our first application in India for leniency, it again was a subsidiary of an MNC. So far, the domestic companies have really not come forward with a leniency application, maybe because of mindset. They don't want to really burn the bridges with their friends, with who they have been cartelizing for years, for decades. So they don't want to. And another thing very interesting, in India, even the business houses, they get their sons and daughters married to each other. So they don't want to even spoil their married lives by filing cases against each other. So what I have seen that MNC's subsidiaries have always come forward to file leniency application. As Professor Somasekar talked about that zinc dry cell battery, it was Panasonic who filed it. And the companies who were being actually facing the most difficult situation post that leniency application are the domestic Indian companies who have been in existence in the market for over decades. So now these companies were under such kind of a catch-22 situation that they neither can say that they are not in cartel, nor then they can say that they are in cartel. So in the process, when the final order had come out, one of the major Indian dry cell manufacturer was handed out with such a huge penalty because the scheme of the leniency regime was such that the first applicant gets up to 100%, the second up to 50, and third up to 30. So this up to created a lot of problem with regard to the second applicant's computation of penalty. What the CCI has done, they have actually maybe they're very unpredictable in application of the penal provisions of the Competition Act. Sometimes they take Section 27B, and sometimes they take the proviso to Section 27B. As a lawyer, by interpreting the statute, all cartel penalties must be computed under the proviso to Section 27B, because 27B is only relatable to computing penalties for vertical agreements and abuse of dominance. And if I use the word provided, in case of cartel, the penalty shall be 3 times the profit or up to 10% of the turnover during the period the cartel operated, which clearly means the intent of the legislator was to impose higher penalty for a proven cartel. And again, the higher between profit and turnover should have been computed. Now, if you are making 10% of the turnover for one set of cartel investigation, and you are doing it profit under 27B for another set of investigation, the jurisprudence evolved becomes unpredictable for industry. So in case of this kind of a problem, where in my personal view, 27B proviso shall only have to be applied for computing penalty. There is no scope to apply 27B, because 27B is typically for vertical restraints and abuse of dominance. 27B proviso is only for cartels and bid rigging. Now, with this discretion being wrongfully exercised, I would say wrongfully, because it actually causes a lot of damage to the industry. Say, for example, in the case of LPG cylinders, the CCI, very interestingly, found that the period of cartel operated until up to 2012. It is part of the DG's investigation report. When it computes the penalty, from the date of passing of the order, they had gone 3 years behind, which is beyond 2012. Now, if your cartel operated allegedly up to 2012, You have no business to compute the penalty from 2013, 14, 15. Because according to your own investigator, who is a specialized investigator, he is saying the cartel ceased to operate after 2012. So if you had applied 27B proviso, you should have actually done the correct analysis. Since you applied 27B only, you had taken 3 years prior to passing of the order. So this became one of the main contention of the appellants before NCLAT, that CCI computed the penalty wrongfully. Now, this is a part of evolution of the law. Now I come to beer. In the beer cartel case, there were 3 players operating and it was arising out of a leniency application. Again, the leniency applicant is an MNC. Now this MNC, when it filed the leniency application, it enabled the CCI to form the 26(1), that means the prima facie order. And not only, CCI concluded that since the first applicant was able to help us in forming the prima facie view, the DG also found that the prima facie view and the evidence given by the first applicant was so clinching that it went on to cause a dawn raid under section 41 subclause 3 with the warrant of the CMM, New Delhi. After the dawn raid, the 2 other applicants also filed leniency application. Now, the judgment was very interesting. In case of the market leader, the CCI found their profit was higher than their turnover during the period of the cartel operated. And for the other 2, they found that the turnover was higher than the profit. So they imposed the penalty by computing turnover for applicant 1 and 3, and they computed penalty for 2 on the basis of profit, which to my mind is the absolute correct way of computing penalty, because the law says higher between penalty and turnover, and they have calculated it correctly. Of course, that matter is also sub judice before Supreme Court now, because NCLAT did not agree with the appellant, who I am not disclosing who the appellant was, but the appellant's view was that they were not into cartel. The NCLAT says that how can you now say that you are not into cartel? Post dawn raid, you filed the application, and now you are saying you are not into cartel, and they are giving the argument of appreciable adverse effect, etc., which the NCLAT, of course, did not find to be acceptable. Let us see what happens in the Supreme Court. But what I am saying here is that the computation of penalty itself can really lead to predictability of the implementation of the law. Because as we all agree that cartel is the most pernicious form of anti-competitive practice, hence the deterrence must be maximum. Since our law is not criminal sanction, there is no jail term for the individuals, there is no penalty which is open-ended. Law has defined what the penalty should be, and simply it should have been within the proviso. If the proviso has not been invoked, in some cases it is 3 years turnover has been taken, and in 1 or 2 cases the proviso profitability has been taken. So that is what, makes it little unpredictable, because in the case of, say, LPG cylinder, as you know, in Rajasthan cylinder case, Supreme Court said that whenever there is a bid rigging, the buyer cannot dictate the price to the seller. It becomes monopsony. And if the buyer is in a position of dominance, and if it says, this is my price, all of you supply at this price, then obviously the concept of bid rigging goes off, because it is not the agreement of the competitor supplying the LPG. It is the buyer who is dictating the price, and hence the competitors have no choice but to agree with the buyer so that they remain relevant in the market. Economic viability issues arise, otherwise they will blacklist and the parties will not be able to participate in the tender in the subsequent notice inviting tender. So all of these evolution may be very interesting, but at the same time, it is not giving a predictable signal. So if it is not giving, for example, flashlight case is being relied upon by more often than not anyone facing a cartel investigation. Now, flashlight ratio of the CCI, to my mind, is very weak in the sense that despite the fact that all the 3 players in the market have filed leniency application. During the and the DG concluded in the investigation report that yes, it's a cartel. In the final argument, parties came up and gave the economic justification of appreciable adverse effect being not proved, and the CCI agreed despite it was a leniency application. Now that flashlight is one of the aberrations, in my view, which constitutes an unnecessary defense against cartel arising out of leniency application. Every leniency applicant, whosoever comes in defense before either CCI or in appellate tribunal, 99.9% time they rely upon flashback ratio. The flashlight ratio is a complete negative ratio, which actually helps parties to get away with the investigation and the leniency penalty. So what I'm trying to say here is that the whole idea of having a leniency regime qua the MRTP commission, why did Raghavan committee say that there should be a leniency application, there should be effects doctrine? Why? Because during the time of MRTP commission, I remember ANZAC versus alkali manufacturers, it was being handed out with a cease and desist order that was only available under the MRTP Act. In appeal, Supreme Court though concluded that yes, there was a cartel being imported into India by ANZAC. However, since you do not have effects doctrine as part of your substantive law, the effects what may have happened in India cannot be theoretically computed. Hence, the law does not have enabling provision. Section 32 has been included in Competition Act to bring in effects doctrine. And at the same time, leniency was not part of the MRTP Act, which is now brought into the Competition Act very categorically. So once we have made a departure from a plethora of ratios of MRTP Act, we have to move on further. Now we have got enabling provision like leniency, effects doctrine, dawn raid. All of these must be utilized in a manner which would make us a clear departure from MRTP commission. Here, Dr. Navneet, I would like to just give one reference. In one of the cases instituted under Section 33 of the MRTP Act in the year 1990 of cartel, which is typically, the number is 99 of 1990, that was being disposed of in 2007 December. And the Honorable Chairperson of the MRTP Commission said that it took 17 years to give this final order. By this time, the companies who were actually originally involved in the cartel may have restructured themselves here and there, and the ultimate effect of this order may not have any impact on the rectification of the market failure, which the law intends to do. Unfortunately, the matter is still sub judice in Supreme Court. From December 2007, we are sitting in 2023, the matter is still sub judice. Now, to answer your question, during this period of 1990 until 2023, many of the cement companies have restructured, either exited the market or there has been a merger acquisition happened, and they have practically sorted the issues relating to cartel penalty. Say, for example, a weaker cement company, instead of facing a cartel investigation, it found it better to sell itself off to a better cement company and get out of the market. And when they were entering into the M&A agreement, they were sorting out their rights and liabilities, including the penalty of the cement, which may have arisen out of either Competition Act or of MRTP Act. So this clearly makes some kind of an intersection between M&A and cartel. So if I say, I'm not saying that every industry is going to remedy the way I'm explaining it to you, but if the decision of the commission with regard to cartel is not expeditiously disposed of until up to Supreme Court, when a finality is to be reached, the whole purpose of the market is defeated, because the companies who are having very less market share and do not have much to really gain from the industry, they might like to get a restructuring happen by selling itself off to another businessman. So in the process, the M&A is becoming a safe harbor against cartel. This is my limited point, which we can discuss, but that is what I have seen, that this has happened many a times whenever a cement company is being handed out with a penalty of cartel or bid rigging.
Thank you. This is very interesting perspective, how the merger route can be utilized by participant of a cartel. Very interesting. But Professor Somasekar, what I hear from both of you is that the leniency regime really could not unsettle the existing cartels. What it unearthed were some of the past cartels and very limited existing cartels, For the audience, for the professional world, can you list out some of the methodological reasons, the methodological inconsistencies, just to list them out so that readers, our audience can understand that these were the infirmities which caused erosion of the effectiveness of the leniency regime. Can you
Sure.
list some of them? Yeah.
Yeah. And some of what Mr. Manas said as well is going to be corroborated by our data over here, very interestingly. But before I jump into empirically, showcasing why exactly we do not have so many leniency applications, or why we do not have the discovery of more existing cartels, I want to base it on the biases that exist in the Competition Act itself, which were not rectified by the recent amendments. Firstly, the penalty is levied on total profits. It is not on excess profits, which is fine because CCI may get into a quagmire trying to estimate what exactly excess profits were, and then in turn leads to litigation, because it becomes a very tricky exercise in statistically trying to establish what exactly was excess profits, although there are methodologies evolving in that particular area. So the first thing is that given the way in which the penalties are designed, it's quite possible for you to have higher penalties on other types of agreements than cartels. It's entirely possible. Secondly, there is a bias within the penalty system which can lead to less successful cartels being penalized comparatively more than the more successful cartels. That is how the provisions are aligned. Now, therefore, it becomes very imperative that when CCI has to decide how it should levy a penalty up to 3 times the profit and up to 10 times the turnover, the methodology that it uses in order to decide what should be the actual penalty has to be very, very clear. Now, the clarity that is required in how, and this is to just explain why we don't have, is because, firstly, as Mr. Manas has already pointed out, how exactly is CCI using Section 27B and the proviso to Section 27B, which is what should be used for cartels and bid rigging. But unfortunately, in certain cases, CCI says this is cartel-like behavior and then penalizes them under the main Section 27B, but not like cartels. And at the same time, it also provides them leniency benefit. Now, it's completely contradictory. If you call them a cartel, they're eligible for leniency. But you don't call them a cartel because you've penalized them, under 27B, but not the proviso. So how do you apply the leniency proviso? How do you apply leniency for them? So that's a contradiction. And then if you look at the data, out of 29 distinct cases, 23 of them have been penalized under 27B and not under the proviso, which obviously says that your penalty is not being deterrent enough in the way in which you apply it. But the first transparency, or not more than transparency, clarity that is required is methodologically, how do you distinguish between the application of 27B and the proviso to 27B, because you've employed both? When do you state? That's the reason why we created 2 different types of cartel definition based on CCI's enforcement. It appears that in certain cases, they're calling them as hardcore cartels. And in certain cases, it calls them cartels, but penalizes them under 27B, which means there's a new distinct category called as non-hardcore cartels. Now, how exactly do you decide between these 2 types of penalties? That's not clear. So that is something which CCI, having gradually evolved now, it's time to look at it and say, you know what, these are the reasons why we did it. Maybe there is some lack of clarity. So we're going to list it out now and say, this is when precisely you're going to be penalized under the proviso. But until that happens, there's a methodological lack of clarity. The second methodological lack of clarity, which very easily can prompt litigation, is how exactly they compute the penalty. Once having chosen the penalty base, whether it's the proviso or the main Section 27B, how do you decide whether it should be 7% of the turnover, 2% of the turnover, or 10% of the turnover? Or how do you decide whether it should be 1 times the profit, 2 times the profits, or 3 times the profits? How do you, and the main factor that they employ over here are mitigating and aggravating factors to decide at what level they should penalize them. Now that becomes very critical because there are already biases in the way in which the act itself is framed. Now, in the employment of mitigating and aggravating factors, of course, even before you come to mitigating and aggravating factors, Mr. Manasji has already pointed out that, you got to choose between the higher of 10% of the turnover or 3 times the profit, whichever, right? That's what you got to choose. And very interestingly, in that case that was being discussed earlier, in one case, it turns out that the third firm was charged a multiple of profits, which turns out to be exactly the same multiple of profits as the other 2 firms which had charged a penalty on the basis of turnover was. So they were actually trying to tweak it to match all 3. But the whole point of saying that you should take the higher of these is to somehow correlate it with the harm or the gain that a firm has got. But that purpose is lost. So that's a problem, right? Now, the other thing that we find in terms of employing mitigating and aggravating factors, if you look at these statistics here, this is a sort of analysis of how CCI has employed mitigating and aggravating factors. So this is a 2x2 matrix. So let's look at how this goes. If there is no mitigating factor, and if there's no aggravating factor, the penalty is on an average 6.67% of the turnover, right? Now, no mitigating, no aggravating factors means that there's really no aggravating factor which causes penalty to go up to 10% levels, or no mitigating factor which causes it to go down to 0%. Now, if you look at no aggravating factor, but only mitigating factor, it is 2.63%, right? And now let's have a look at this. There is an aggravating factor and there is mitigating factor. This is 5.03. And then finally, you have aggravating factor and mitigating factor 2.46. Now, I'll show you how these are inconsistent when I show you the econometric, analysis. Now, when I take CCI's categorization of cartels into hardcore and non-hardcore cartels, and I look at how they have penalized firms on the basis of mitigating, aggravating factors. Here, firms have only mitigating factor. What is the penalty? And firms which have only aggravating factor, AF, what is the penalty? Firms which have no aggravating and no mitigating factor, what is the penalty? And firms which have mitigating and aggravating factors, what is the penalty? Now, let's have a look at hardcore cartels. Firms which have mitigating factors, only mitigating factors, have on an average, for every 1 rupee increase in revenue, they have 0.21 as the penalty that is levied. Now, when I look at, this is for mitigating factors. When I look at firms with only aggravating factors, statistically, it's non-different from firms with only mitigating factors, which is an anomaly because firms with only aggravating factors should be far higher than those with only mitigating factors. Now, the same with firms with no aggravating and no mitigating factors, they too are statistically non-different from firms with only mitigating factors. Now, this is, not really correct. There's something problematic here, which shows that there's a lot of inconsistency in the way in which mitigating and aggravating factors are employed. Now, I come to non-hardcore cartels, which means although they are cartels and bid rigging instances, but they have been penalized under 27B. Now, in their case, if you look at it, it's 0.02 for firms with only mitigating factors. Those with, that is the lowest, which is quite consistent. But those with aggravating factors are lower than those with mitigating and aggravating factors. And interestingly, those with mitigating and aggravating factors, has a sign which is, quite inexplicable, right? So there's a lot of inconsistency in these 3 categories here, which is not how it should be, right? So in terms of methodology, that the CCI uses to decide penalties by applying mitigating and aggravating factors, it is really not clear at all. It is really not methodological at all, and there are obviously inconsistencies which are involved over there. What is the result of that? Now, the result of that is obviously that there's a lot of incentive for firms to go on appeal saying that, look, how did you decide my penalty? What is the methodology you use? And we are not stating this like as if ours should be the only competition agency to do this. The FTC uses guidelines. The European Commission uses guidelines when applying mitigating and aggravating factors. So it's time now. The CCI has had some time. It was a young agency, but now is the time to go deeper and address some of these uncertainties and develop a more methodological approach towards how you'll apply mitigating and aggravating factors. The other methodological problem that we have is how they have actually penalized individuals. Whenever a firm approaches CCI with a leniency application, individuals have been consistently penalized. In the case of other cartel cases, it's been very rare that they have actually penalized individuals. Now, this is quite puzzling. It's like, an availability heuristic. Like, I know that this is a cartel, they have come forward, so let's penalize these guys. But when it comes to the other cases, when you yourself have to investigate and dig out and establish, you're very reluctant to penalize the individuals. Now, that's a problem, because then individuals will say, it's better not to go for leniency, because if I go for leniency, then I'm going to get affected, I'm going to get penalized. Right? So these are three problematic areas in terms of methodology of CCI, which we feel may not encourage leniency applications, one, and secondly, may also encourage further litigation, therefore causing delay in the application of penalties.
That's really quite a systematic elaboration of the methodological infirmities, and I read from your paper about these individuals, what you're saying, that faced with a prima facie finding, employees concerned would have preferred to prevent a leniency process to avoid individual penalties. However, this development falls short of an explicit whistleblower clause that could have encouraged aware but not necessarily involved employees to contact the CCI directly. So this individual behavior needs little more elaboration.
Yeah.
And let me turn to Mr. Chaudhuri, how he has seen this at play, how individuals have responded to motivation to use lesser penalty versus the corporate, which we have already discussed.
Before coming straight away to your question and the answer thereof, I would just like to add one point with regard to the penalty guidelines. After this amendment, which has been given effect to from 11th of April 2023, and the notifications are coming out one after another, and I think many of the notifications are still in the way to come up. Penalty guidelines has now been put as a substantive provision of the competition law by way of an amendment. Now the CCI will come out with a notification as to how they will really make the stakeholders understand as to what should be the way forward for them to understand how would the CCI compute and calculate the penalty. So penalty guidelines are on the way. It is about to come. Second issue I would like to also add, the Parliament has added another deterrence. The second deterrence is that whenever there is a penalty handed out to a delinquent individual or a company, in order to successfully file an appeal before the NCLAT, the parties will necessarily have to pay 25% of the total penalty, either of the company or on the individual. That is condition precedent to get an appeal admitted, instituted rather. So if the appeal has to be instituted, if you are handed out with a penalty of 1,000 crore, 250 crore goes immediately. How does that remain in the custody of the registrar of the NCLAT or of the NCLAT itself, or it might get deposited into the Ministry of Corporate Affairs? This is yet to be seen. But I am telling you, if it goes to the government exchequer, that is the nodal ministry, And if the party wins the matter in appeal, either at the NCLAT or at the Supreme Court, I think it would be very difficult to get that money out from the corporate affairs by way of I don't know how the money from government exchequer which goes into the consolidated fund of India can be retrieved if the party wins. That would be another set of litigation. So this is one area of deterrence which would be evolved. With regard to the questions of Dr. Navneet, that how does the individual where the company has to be looked into from our own experience as a practicing lawyer, I'll tell you initially, if I go back to the first cartel case, that is FICCI versus Multiplex Corporation, the total penalty imposed by the CCI was to the tune of 1 lakh rupees, which was peanuts for the film industry. And naturally, to go before appeal, to get that appeal instituted and challenge the CCI, the film industry decided not to appeal. So 1 lakh was a penalty which the CCI argued that since the cartel operated for only 7 days, I need not really go to the whole up to 10%. I can just make it as a nominal penalty to show that the cartel is proved. So that was initial year. When it came to sugar cartel case, it was very interesting because the sugar had two components. One was the state advisory price and one was the minimum support price. So in UP, which is again a sugar producing state, had a higher state advisory price than Maharashtra. And the cartel was detected in Maharashtra. So the UP sugar manufacturer said, I had no opportunity to take truckload of sugar with a higher price, sell it at a lower price in Maharashtra. So obviously the cartel could not really be substantiated between UP and Maharashtra. So those were the initial years when these economic arguments were considered very, very important. Then came the next wave of the penalties where individuals were initially, in case of first round of cement cartel case, which is 6,700 crore for 10 cement companies, there was no individual penalty imposed on that time. It is not that the CCI was not aware. They were aware, but they wanted to really make the penalty because, you know, I remember when there was the order came in June of 2012, the chairperson was being interviewed in Bloomberg. And the reporter had asked, why did you impose 0.5 times of the profit when you could have gone up to 3 times of the profit? So I remember the answer was that if I had imposed full 3 times, the cement industry would have wound up because it would have immediately resulted into 42,000 crore from 7,000 into 6. So they had that kind of an argument at that point in time and not to penalize individuals. But over the years, during the course of the practice of this competition law, both by the CCI, the Director General, and also the Ministry of Corporate Affairs, they found that actually the problem lies with the individuals. It is not the brick and mortar company which is into cartel, the individuals are into cartel. And that is the time in 2017, the leniency regime, that is the lesser penalty regime, was amended. 2 things were added. One, not merely 3 should be given immunity. Beyond 3, if there are more applicants for leniency, they can also be considered. And individuals can also file leniency application so that they also get the benefit of mitigation. Question arises, how do you really compute up to 10%, up to 3 times profit? It is generally being told in public discourses, in advocacy programs, that it all depends upon case-to-case basis. Say, for example, in the paper pulp case, they are all being handed out with a cease and desist order, despite out of 120 paper pulp companies, 30 had filed leniency application. Now these 30 have admitted guilt because leniency application filing means admission of guilt. Question arises, will you really let off the remaining 90 whose also clinching evidence was found by the DG? In such circumstances, it became such a huge confusion for CCI. Do I segregate 30 qua 90? And it, mind you, it was not 120 paper pulp cases. There are 720 paper pulp cases. That means 600 were not investigated at all. But the market is distorted by all the 620. So for an agency like CCI to remain neutral, it decided to impose cease and desist against everyone. Because the first 30 who filed leniency application, they were having market share below 1%. So in such circumstances, they are already MSME. If you impose penalty, and since they are relying only upon the scrap paper pulp as their raw material, and that market was very vulnerable during the time of COVID. So all these things became mitigating factors. So what I'm trying to highlight here is that, to be fair with the regulator, in some cases, if there is an oligopoly, say three players, six players, say for example, if I give example of say passenger tire, there are about 10 tire companies who comprise about 90-95% market share. The vulnerability of a cartel is very high in comparison to LPG cylinder. After this Ujjwala scheme, the LPG cylinder bid rigging has almost gone out of window. There is no scope to really investigate, because there were about 60 LPG cylinder manufacturers until the Ujjwala scheme came into being. With 2016 Ujjwala scheme came, it is about 200 plus LPG cylinder manufacturers. Now, the market has become so fragmented, it would be very difficult to coordinate cartel. So the markets change so fast. For economists, it would be always easier to really pinpoint, and whenever CCI has got a very strong economic wing, they would always see oligopoly versus non-oligopoly. So if it is non-oligopoly, they would be definitely try to see whether really it is causing impact on the market. If it is oligopoly, obviously. But even in the oligopoly, in the first round of tire cartel case, we gave an argument that out of the 5 or 6 tire companies investigated, the market share between them fluctuated during the time of investigation. And it fluctuated substantially. Not that 0.5% or 6%. It's fluctuated from say 3 to 7%. So with the market share during the period of cartel, alleged cartel, the market shares remained very unstable. CCI was not willing to really pinpoint that there was a cartel. And since the market, the person who was actually not into some kind of a trade association was relying upon the market information, there was no direct evidence of talking to the enterprises. So all of these, over the years, if we can look into this, non-leniency cases versus leniency cases, oligopoly versus non-oligopoly, repeat cartel versus non-repeat cartel, I think we'll get a picture where we can say that there are certain industry which are very low-hanging fruit for any competition agency, so is for the CCI. So this is what we have experienced, and I'm repeating that thing. Sorry for being repetitive. In the initial wave of leniency applications in India, all were mostly MNCs, their subsidiaries. Domestic companies have really not filed leniency. Paper pulp is one example where it has been filed, of course, correctly in terms of the lesser penalty provision, but it did not survive because it did not make any sense for CCI to impose penalties. They are so small, fragmented players. So I think in conclusion, we can see that the amendment, first of all, would bring that 25% element, which would be a substantial deterrence. Second, they have added hub and spoke, which can really cause a very significant damage to trade associations because they would be considered as hub and all the competing members would be spokes. So that is one area which I think CCI has been imposing penalties under Section 3, Subclause 1, which they have mitigated by this amendment with the hub and spoke cartel. I think that may be another area which is very interesting to be seen when it gets evolved. And third, which of course, I don't know whether that would be right analysis of as a lawyer, but I can definitely tell you, with the DG merging into CCI, I think the things may be easier for the commission, but it would be more difficult for the parties who would be appearing before DG. Because an adjudicator and an investigator, if they are subsumed into each other, and as we know that more often than not, DG is to be administratively controlled by the CCI, they would tend to really remain subordinate to the adjudicator, and which may compromise the quality of the investigation and the inquiry. I stop here unless you have got some other questions.
No, I think we have discussed the origin, the development, and responses by corporate responses by individuals. As we come to the conclusion of this session, I want to mention two things. Firstly, increasingly, we are seeing in the markets, even oligopolies are disappearing, and we are seeing sector after sector duopolies. Two principal competitors existing. I can count in one breath at least 1 dozen markets in India itself where we have duopolies. Theoretically, that is a fertile ground for collusive behavior. So that's my first point. The second point is that the Competition Commission now is in the process of bringing leniency plus regime. So therefore, I want your concluding remarks on the design principles which should inform the leniency plus regime if it has to see any substantial success in India. How can it be really viable and successful? How can it yield a desired outcome going forward? Let me begin first with Professor Somasekar.
Yeah, sure. Thank you. So, but just to, there are a lot of good points that Mr. Manas pointed out here. And some of those cases, like the FICCI case, we excluded from our data set because that would have skewed the results and things. And the other thing that we have to point out is that the CCI has actually in almost every case tried to identify mitigating factor or aggravating factor. In certain cases, it is not identified either. The only problem is how are you employing these mitigating and aggravating factors? That is where the lack of clarity is, and which brings a lot of issues. So coming straight away to this question of, in fact, I think there's one study which has come out which points to increase in concentration in certain oligopolistic markets. And that seems to be very similar to what the so-called neo-brandy school is pointing out in the US, that there's increasing concentration in the US markets as well. Well, while we say that, at the same time, of course, we are all aware that the Competition Commission is not about the degree of concentration, but it is about the actual conduct of firms which are in these types of markets. But what is important is to understand and review certain decisions of the CCI to see if earlier decisions that were taken, say for instance, maybe it was a case of predatory pricing. Let's have a look at that and see if there was something wrong that went there which led to this kind of increased concentration in the market. Did they have a very static perspective? Did they have a very narrow perspective of what defines dominance, which allowed them to ignore certain factors and therefore possibly lead to increasing concentration in a particular market where you have a duopoly, almost a duopoly? That is one thing. The second thing is, while we say that, yes, there is increasing tendency of concentration, we at the same time need to, understand if there are structural factors in these markets which allow for cartelization. When I say structural factors, are these firms producing homogeneous goods? Are these firms existing in a very technologically savvy, sort of space where there's constant evolution of technology? What is the kind of interaction that they have with buyers? Are they many dispersed buyers where the price is transparent, or are there transactions very infrequent with very limited parties where the prices are not really public knowledge? Now, it would be interesting for us and also important for us to first develop structural screens and identify those particular markets where there is a strong potential for such type of cartel behavior. Then the next one is to go in for behavioral screens and tests and see, well, we have the structural factors. Now let's see behavioral, maybe in terms of prices, maybe in terms of, we can use statistical measures like coefficient of variation of prices, or, we can also have a look at the profit margins and compare them with similar industries outside or within the general industry and see how the trends have been. You can even use market share statistics and see if there are any structural breaks in the patterns. So these are ways in which we can employ some less, intensive methods in order to, just screen and see. And if the screens throw up any red flags, then, it's a good time to say, okay, maybe the CCI should look into these cases instead of going into a full-fledged investigation.
Right. How can we make Leniency Plus more successful, Mr. Chaudhuri?
First of all, question is that, are we really interested to make the Leniency Plus successful? I mean, the question would arise, how would you make it? Before that, we must say, is it necessary? Now, question is, Leniency Plus typically means that a multi-product company who is into cartel in one product and is being investigated. And during the course of investigation, it wants to mitigate its penalty in the first cartel by exposing other cartel members in a second cartel where it wants to get the benefit of a first applicant or a first priority status marker. This question would only arise, in my view, on case-to-case basis. First of all, we have to identify who are the possible takers of this Leniency Plus advantage. First of all, we must find multi-product companies. And in a company which is a multi-product company, most of its products are into oligopoly. So those companies would be first to go for Leniency Plus benefits. If it is, I'm hypothetically saying, I'm not saying they will definitely go. Because as of today, so far the evolution of the leniency regime in India clearly indicates a very lopsided applicants in favor of MNCs. That means the domestic companies have rarely taken advantage of the leniency regime in India. So it is, if the trend continues, the domestic industry who are in a multi-product business and all of their businesses are more or less oligopoly, then only those companies can file Leniency Plus benefits, with the caveat that the domestic industries have very rarely ventured out to file leniency applications in India, whether they will file the Leniency Plus. So if they have not exercised the option of leniency benefits, will they venture out for a Leniency Plus? Now, Leniency Plus becomes a condition precedent that it is already being investigated for one leniency and where it is an applicant. Only then it would go for Leniency Plus, because it would try to enhance its immunity from the penal consequences in the second round of leniency. So it is all, in my view, dependent upon how the industry will behave. Enabling provisions, may be there in the law. That's nothing bad about it. Whether it would really happen is something which I would wait and watch, because in Leniency Plus globally has not been found to be very successful. If you see, the Leniency Plus is, again, we have borrowed it from overseas, and the jurisdictions where it has been borrowed from are not really having much of jurisprudence on Leniency Plus. So I would like to remain in a wait and watch kind of a situation. But the enabling provision, as a lawyer, I would always welcome, because enabling provision means that at any point in time, any party who might get more benefit by filing a second application under the Leniency Plus will get that opportunity. But I am not really sure whether it is going to benefit, because the leniency has not benefited so far, insofar as the domestic industry is concerned. Queer the market, not the company. I'm talking about the market, whether the markets have really been rectified by leniency applications. It is still a work in progress. We are not sure whether the Leniency Plus will be really able to jump the gun and become more powerful. It's a big question mark for me. I've been participating in several of the international amendment process in other jurisdictions. I found a very interesting question in one of my groups, which is a global group. They were asking me a very fundamental question, that if the concentration post combination in a market which is oligopoly, as you said, duopoly, if it enhances substantially post combination, does your commission entertain follow-on action against the concentrated combined entity? Now, this is something which is being considered by many Western jurisdictions, that fair enough, you allow two big players in the market to come together, and number 3 becomes number 1, and number 1 and 2 remain in the market. But the combined entity gains a market share of 65% plus. Will the people who would be aggrieved by this combination can file a follow-on action and a damages claim against the combined entity gaining a concentration from 45 to 65%. If this is going to happen in Western jurisdiction, then your question is answered that even a merger control with an enhanced concentration can become a problem in future.
That's really a very particular or peculiar problem to be watched for. Professor Somasekar, last word from you.
Yeah, I just want to have a few words on the leniency plus. Now, you've already seen that the leniency program has failed, right? And empirically, we have shown that why leniency takes place. And Mr. Manas has clearly pointed out some very interesting reasons as to why leniency has failed, right? Now, if leniency has failed, firstly, there are certain other reasons why they've not come forward. Because the moment you say that, yes, I admit that we cartelize, you can have follow-on actions, claim for compensation. Now, that's going to enlarge your bill of, that we got to pay. Now, that's one of the important reasons why they've not come forward with leniency applications. Now, look at the other very interesting aspect. In almost all the cases involving associations, none of the firms have come forward with a leniency application. Associations are mechanisms to establish strong relationships between these firms. They don't want to upset the apple cart. They're going to exist with these other firms for many, many years to come. They're not going to step in and say, okay, I admit to this. They've got to live the rest of the years with the competitors who are going to, not cooperate with them. Maybe it's with respect to a government policy or whatever it is. They're going to face hell. Now, that's a cost that they're not going to bear. That's the reason why you have MNC firms who are more willing to do it rather than Indian firms who are part of associations. Very clearly, the evidence is stark. You're a part of an association, you'll never see a leniency petition, leniency application, right? So I think it's very important that we try to increase, again, the probability of detection, which is the very, very, important aspect and which is very, very low, which can enhance CCI. Leniency is supposed to do that. But that's the reason why I'm saying have a whistleblower provision which provides a reward. The Securities and Exchange Board of India has something like that. Now that can really threaten them.
Thank you. I must thank both of you for this very dispassionate but very intense discussion on cartels.